Welcome to Criminal Law Video Presentation number 6. This presentation will cover the topic of causation. Causation becomes an issue when we have a result crime or when an element of a crime involves a result. And the question we're trying to resolve is whether the defendant's conduct and what that conduct brought about are sufficiently blameworthy or connected enough to criminally punish the defendant. So let's take a look at some examples and will help us sort of start to sort this out and see the rules that apply. So the first example we have is D strikes Z, Z dies immediately. Obviously in this instance there isn't much of an issue of causation. Obviously it would be easy to say that D caused Z's death. In my next example, D strikes Z, Z goes to the hospital and dies 5 days later. Well, the only question to be resolved there is, did Z die 5 days later as a result of the wounds inflicted by D? If so, again, causation probably will not be much of an issue. But now things get a little more complicated. D strikes Z, Z goes to the hospital is hit by a tornado, and D dies. So in this instance, was there an intervening event which will break the causal link from D striking Z to D's death? Well, that is to be resolved, as you'll see. Finally, D strikes Z, Z goes to the hospital is hit by a tornado, D suffers multiple cuts, gets an infection, gets antibiotics, and dies from an allergic reaction to the antibiotics. Well, obviously here we are adding a number of other intervening events between the time D struck Z and Z's eventual death. So let's take a look at how the law starts to sort this all out and figure out what to do here. So causation, you will learn, always involves a two-part analysis. The first part is the but-for analysis, which we'll talk about in a minute, and the second part is the proximate cause analysis, which we will discuss after the but-for analysis. But both of these analyses have to occur. That is, you must first resolve the but-for analysis, and then you must resolve the causation analysis. And now let's take a look at one way to conceptually think about this two-part analysis. I like to think of but-for as a fairly large set, and you'll see why in a minute. That but-for includes a lot of results that may have come about because of the defendant's conduct. And then when we layer in the second part of the test, proximate cause, we are clearly reducing the size of the set, and we are narrowing the number of instances in which the defendant will be held criminally liable for the result of their conduct. Now, but-for. The simple test for but-for is the antecedent but-for the result in question would not have occurred when it did. So in this instance, the question to ask is, but for the defendant's conduct, would the result have occurred when it did? And so you can see this could take in a lot of conduct that we have going on. Let's take a look at our examples. But for D striking Z, and then Z dies immediately, clearly this meets the but-for test. Z is struck, goes to the hospital and dies 5 days later. Again, if Z dies from the wounds that D inflicted, but for D striking Z, Z would not have died. Now we add in an intervening event, the tornado here, and hit by a tornado, and D dies as a result of the tornado. But we can still ask, but for D striking Z, Z would not have gone to the hospital, and the hospital would not have been there when the tornado hit and would not have died. So there is real likelihood that D still meets the but-for test as to Z's death. Now, in my last example that we gave here with the tornado, the multiple cuts, the infection, the antibiotics, the allergic reaction, we're starting to get pretty far afield on the but-for test. But still, Z wouldn't have gone to the hospital, wouldn't have been there when the tornado struck, wouldn't have suffered the multiple cuts, wouldn't have gotten the infection, wouldn't have gotten the antibiotics, and would not have had the allergic reaction. So had D not struck Z, none of these things would have happened to Z, and still yet D still would meet the but-for test as to Z's death. As you can see, this is a fairly large and expansive group of results. Now, one last I'm going to add in here. D strikes Z. The next day and Z isn't hurt, that gets up, walks home. The next day while walking to the store, Z is hit by a bus and dies. Well, clearly in this example, D's conduct is not the but-for of Z's death. And in fact, it has nothing to do with it. So but for D striking Z, you cannot say that Z would have died the way that they did. There was clearly a superseding, intervening event, being the bus coming along and striking him. So there are a couple of other instances that seem to confuse or lawyers, judges, in this but-for analysis here. One of those is when there are intervening events or a subsequent event that accelerates the death. So A shoots Z in the stomach and Z would die in an hour. D shoots Z in the stomach, would die in an hour from this wound. But because of the two wounds, Z dies in 5 minutes. In this instance, both A and D2 are said to meet the but-for test, and especially D2, because D2 and A both accelerated the death. You'll see this playing out in the case that we read, the Oxidine case. In that instance, Oxidine is said to have delivered a intervening blow, but the doctors could not say that that intervening blow that was non-lethal accelerated the death. And without that, the court is not willing to find this antecedent but for in the causation issues. The second issue where this comes about is concurrent sufficient causes. In this instance, A shoots Z in the heart, and simultaneously and independent, B shoots Z in the heart. Z dies instantly. In this instance, it's said that both A and B meet the but-for test in this matter. So but for A's conduct, Z would not have died when he did and as he did, and but for B's conduct, Z would not have died when he did and as he did. In both of these instances, these two actors, A and B, are said to meet the but-for test here. Now, obviously, this is pretty far-fetched and almost never, ever, ever happens until eventually one day you read a case where it actually did happen. But it is still pretty far-fetched and probably mainly hypothetical. Let's start talking about proximate cause for a minute. Proximate cause will give you a great deal of consternation because it is not an exact determination. Proximate cause is really a determination that for those who meet the but-for test, what group of them, remember in that set before, what smaller group are we going to hold criminally liable? The test is mainly stated as, was the result reasonably foreseeable to the original actor? Well, you're going to find when you start working with this that this is not going to be a very helpful explanation. Some things to one person are reasonably foreseeable and not to another. As a result of this, when you read in Dressler, Dressler is going to have essentially 6 factors where he has grouped proximate cause analysis into these various factors. I have placed on the Twin site the reading from Dressler that discusses these various factors, and you will see in looking through them that he has actually taken the cases and grouped them as to when proximate cause is found in each of these instances and when courts won't find proximate cause. You will find that in your reading in the case book, you have a case where the court basically says that the victim reached a place of safety and then placed themselves in harm's way, therefore breaking the proximate cause connection that would have been had in that instance. Look at the facts of that case, look at how Dressler breaks down these various categories, and you will start to see how proximate cause plays out. Finally, the Model Penal Code deals with proximate cause very differently. The Model Penal Code really creates two analyses. One, it retains the common law but-for analysis, exactly as we talked about it above. But for the defendant's conduct, the result would not have occurred as it did and how it did. So that's the first piece of the analysis. The second part of the Model Penal Code analysis is really creating a jury question. The jury question, when the element, the causal element, must be done purposely or knowingly, is, was the actual result involved the same kind of injury or harm as that designed or contemplated, and is not too remote or accidental in its occurrence. So it's tying it to the purpose and knowledge. It's tying it to the culpability element. Was the harm purposely or knowingly designed or contemplated, and then was the final result, is it not too remote or accidental? And when the culpability element is reckless or negligent, as you can see, the question then becomes, the actual result involves the same kind of injury or harm as the risk perceived. That would obviously be recklessly, conscious disregard of a substantial and unjustifiable risk. So did it involve the same kind of harm or injury as the risk perceived? And then for negligence, or which the actor should have been aware. And again, it asks this second question, is not too remote or accidental in its occurrence to have a just bearing on the actor's liability. So in this instance, the jury would be asked, depending on the culpability that attaches to the result, these questions. This brings us to a conclusion of this short video presentation 6. After the video, you need to go to the Twin site and take the video assessment for video presentation 6. Thank you.